Welcome to Financial Insider Weekly. I am your host, Michael Gray, CPA. My guest today is Ray Sheffield. Raymond Sheffield. He's an attorney specializing in trusts and estates. He has his own company, the Sheffield Law Office in San Jose, California. Ray has been a lawyer for 11 years, received a JD degree from Santa Clara University and an LLM degree in estate planning from the University of Miami in Florida. Ray tells me that he loves the role of counseling clients in their estate planning. In addition to his law practice, Ray is an adjunct professor in the Golden Gate University LLM tax program. And Ray and his wife live with their two adopted daughters who are ages 4 and 6. And they are from Russia, in Almaden Valley, San Jose, California. Today we're going to be talking about estate and gift problems for a non-citizen spouse. So Ray, thanks for joining me today.
Thanks for having me, Mike.
It's a pleasure. So before we get started, again, I want to caution our viewers that we're discussing issues in a very complex area. So this is to be a starting point for a bigger discussion that you should be having with your own attorney and other tax advisors. Get qualified legal and tax advice. Also, we're mostly addressing issues from federal and California standpoints. So for example, California is a community property state. Most other states are not. So viewers in other states should ask about advice for their local laws. So off we go with some of our questions. Ray, why has estate and gift planning for non-citizens become more important?
Well, it's always been important. Most non-citizens aren't aware that there are different rules that apply to them that apply to U.S. citizens and how they're taxed and how they leave money to each other. But especially now that the government seems to be running out of money or running these big deficits, is while they're increasing exemptions for everyone else, they're not doing that necessarily for non-citizens. And it really depends on your status and a number of complex issues as to whether the normal rules that apply to everyone else will apply to you.
Right. And the other thing, of course, is being here in Silicon Valley, you and I see a lot more non-citizens than maybe we did, 30 years ago. Well, of course, you've been involved in the law practice for 11, but even back 11 years ago, we're just seeing more and more people coming here from offshore to work.
We live in one of the most diverse populations in the country, and we get a lot of people that come in to work at high-tech companies, and in doing so, they accumulate lots of wealth. If their company does well, those stock options, the restricted stock units, and they may not be aware of what the laws are here and how that can impact them.
Right. Okay. Well, what issues come up when a spouse of a U.S. resident isn't a citizen? So in other words, I'm a U.S. resident and now I marry somebody, they're not a citizen. They may be a resident alien, they may have a green card. Well, what comes up with that?
Right. Well, the big issue with your spouse relates to you don't get a marital deduction. And this is something that we just take for granted as citizens, that if I leave something to my wife, for example, that there's no tax that she owes on that because she's a U.S. citizen. But you have to be very careful about giving property to a non-citizen spouse. And there are different rules depending on whether you're doing it while you're alive or when you're dead, and how much you can leave, and also what restrictions there might be on how you give them that property. And so it's not just a matter of signing over a deed or making a check or turning over property to your spouse. You really have to think through some of these issues because they can be severe tax consequences for making a mistake.
Yeah, okay. So what is the annual gift exclusion?
So when you're alive, right, if I wanted to leave something to a non-citizen spouse, currently this year, and we're taping this in 2011, right?
Yes.
It's $136,000. It'll go up a little in 2012 because it's indexed for inflation. But essentially, that's the maximum you can give to your spouse while you're alive. if their spouse is not if they're not a citizen. Otherwise, you start paying gift tax at 35%, and no one wants to do that.
Okay, and so one thing that to help to clarify for some people, because they're familiar with this annual exclusion of 13,000. So basically, this 136,000 that we're talking about replaces that 13,000 for a gift that you give to a non-citizen spouse.
So you can, yes, you can give like $13,000 to your kids, right? And there's no tax for that. So, but with the spouse, you get to give more. But the big difference is you don't get to give an unlimited amount.
Right.
And that's what a U.S. citizen spouse can receive, an unlimited amount. So if you have $1 million home that's in your name, you get married and make it community property, and you give your wife $500,000 now of that asset, you've just made a taxable gift, and you can get hit with a really big bill.
Okay, now you'd still get your lifetime exclusion for gifts that are over that amount. Is that correct?
That is correct. Yes, you do have a $1 million exclusion. That's from I mean $5 million this year. I apologize. It's always been $1 million, and then recently we raised it to $5 million.
Right.
So you do have that for gift tax purposes. If you happen to be domiciled here, and that's another question I will probably address in a minute. But you know, most people who are working here at jobs are also going to be domiciled here. So you do have that exclusion. But now when you make the gift, you're using that exclusion up, which just impacts you later down the road.
Right. And so just to refresh maybe our viewers' memories related to this, or maybe they're not familiar. So for 2011 and 2012, we have this $5 million lifetime exclusion amount. And it's uncertain what's going to happen afterwards. It may, if Congress does nothing, it goes back to $1 million. So we'll see what happens. Also, it is indexed for inflation, so it's slightly over $5 million, I think, for 2012.
I think it's 0.12 extra, so another $120,000 extra next year.
Something like that. Okay. All right. What is a qualified domestic trust?
So this is a special trust then that needs to be created to avoid paying tax when you die if you need to qualify for the marital deduction. So if you're leaving money to your non-citizen spouse, they don't get a marital deduction. So Congress has said, well, we'll let you have a marital deduction if you put the money in this special trust. And of course the goal is so that the spouse doesn't go back to Taiwan or somewhere else and not pay tax on any of this money.
Yes.
So there's some special rules that apply to this trust to make sure that it stays taxable in the United States.
Okay. And the nickname for this qualified domestic trust is a QDOT, just to let people know, because we may be using that term and you may be wondering what the heck we're talking about. Okay. So how can you provide for one of these QDOTs?
Well, there's a couple of ways that you can do this. So ideally, for most clients, they want to set this up while they're doing their planning so that they can make sure that they're taking advantage of what the law is, and also so they make sure that their money goes to their kids and that the surviving spouse doesn't do other things with the money, giving it to someone else, or new husbands, new kids, those types of things. So you have my brain just left. You set this up in your planning so that you get counsel and advice at that time.
So you put it like in your will or in your trust? In
your trust, yes, exactly. Now you can also, if you don't have those things, your spouse can set that up. The IRS has created regulations that allow her to put that money in the trust and create the trust after the first death. But now the spouse is going to have 100% control over what happens to that, and there's a very limited timeline for them getting that done, or they're going to have tax issues that they have to deal with.
Right. Okay.
And the spouse oftentimes isn't aware that that's an issue. So, because everyone else gets a unlimited marital deduction, so they may not even be aware, and then they miss the deadline, and now the IRS is saying, where's our tax?
Yeah. So this is one of the issues. Again, sometimes people try to self-administer their trusts or their estate. That would be even worse, but I don't know if you could get away with it. Anyway, so you really need to see an attorney and ask them if they're familiar with these rules, because they are different. It's not the type of a routine administration.
Exactly, and people don't know what they don't know.
Right.
And that's where, when you try and do something yourself, you can really get yourself in trouble. So talking to a qualified attorney and making sure they understand this area really, can save you money in the long run. The other thing to keep in mind, though, is because the estate tax exemptions are so high, right? It's a $5 million exemption now.
Yeah.
You don't need to do this QDOT unless you actually have more than $5 million in your estate.
Yeah.
And there's a lot of attorneys who say, oh, QDOT, I know what that is. That's for non-citizens. But they really don't understand when they need it and when they don't. And so you end up getting bad advice. Mm-hmm. And really what you need is to make sure, what's the size of my estate? How does this fit into the overall plan? And how do I make this work for me and my family?
Right. So we'll get into the requirements in just a moment, but these QDOTs can actually be a pain. Yeah.
Well, they're certainly more restrictive than having it outright, or more restrictive than the normal process for creating a marital deduction.
Yeah. Okay, well, what are the requirements for one of these QDOTs?
So, well, the first requirement is that the surviving spouse has to receive all of the income that the trust earns. Mm-hmm. So, and then the second requirement is nobody else but the surviving spouse can have any distributions from this trust. So we've restricted this money solely for the benefit of the surviving spouse. Now, thirdly, if you give any money to the surviving spouse out of principal, right, you have to pay estate tax when you make that distribution. And that's paid at the rate when the deceased spouse dies, which right now would be 35%.
Okay.
So you get all the income, but then, if you want any principal, if you want anything above that income, you have to pay tax.
Okay.
And then lastly, and what most spouses really dislike, is you have to have a U.S. citizen or a U.S. corporation as your trustee, which means you don't have control. Someone else has control, and you have to get them to give you the money.
Okay.
And sometimes that's a difficult thing to do.
Yeah. What happens